Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota, and today we have many things to do, to discuss, to talk about, to address. Like, why can't I speak? Why? What happened? What happened? Okay, guys. Hi. How are you? I am happy to be here. Just organizing some things in the background. Don't mind me at all. At all. We are gonna just go ahead and set some of these things over here. Not that you guys have any idea what I'm talking about. Okay. All right, so here's what I'm gonna do. I'm gonna ramble a little bit. I'm getting some people who are confused about the rambling in the comments, which means I'm gonna do it just a teeny tiny bit more. I start the show at 11, but a lot of people trickle in over the first 10 minutes or so. So I take the first 10 minutes to kind of organize my thoughts and just chat before we really start delving into the topics. So bear with me on that. I'm gonna what am I gonna do? Holy cats, guys. My brain is like mush. Oh yeah. I gotta preview something for you guys. Here's the preview. I got this in Tennessee. Someone had the audacity, the utter horrific audacity to provide me with some Fireball whiskey. This is not happening tonight, but at some point we are going to drink a significant portion of this on a stream, on a punishment stream for me when I do something wrong. So we'll figure out what that is sometime soon. Hey, what's up, Arma Rex? We'll figure out what that is in the near future. Tomorrow we are going to delve into the saga that is Tonga mixed with Donga. Oh, hey, Tess. How you doing? We're going to delve into Tonga tomorrow. There's a whole bunch of new information out there about the alleged activities of a severely butthurt internet tough guy who seems to have done not only everything he could to avoid a fight that he challenged someone else to, but he also seems to have maybe commit state and federal crimes, including tax evasion, wire fraud, potentially mail fraud. It depends on the facts. We've got violations of Alabama state law. We've got fraudulent inducement. We've got all sorts of stuff that's been happening. And it's going to be just a mess. And I wanted to start it tonight, but there's a lot to collate and gather. I'm going to try and bring on guests who have the information because I don't think I can sift through the autism. I don't think I can do it and get all of the details. So we're going to go ahead and do that. Did this thing already break? The chat seems to be an absolute disaster. Like it already broke. Again, I'm just gonna go ahead. I'm sorry to stream me. I need to come up with a different way to incorporate both of these chats on screen. But the problem is, I don't have my setup isn't configured for that type of real estate. So I'm going to work on that as soon as I can. For now, I'm going to put the YouTube on because it's the most active chat, and the other one just seems to break constantly. So, AWIG81003, I am not going to skip the defense stream. I'm going to do both, but it may take 2 streams. You're right. It may take 2 streams to get through his current issues, but we're still going to do the defense stream at the end of whatever amounts to be the issues we can identify. So that's all coming. It's all coming. And if you're just tuning in, this is a live stream. If you're watching this as a replay, this was a live stream, so it's a little bit disjointed. I get it. If there's something really interesting, I will do a shorter recap of it. And if you don't like the live streams, I understand. Don't watch. I appreciate you watching. I don't want the live stream to turn you off, so go ahead and watch the shorter condensed videos. I'm gonna probably put up a section of just those so that people know when those pop out too. Anyway, Tonka is coming up starting tomorrow. Like I said, I'm gonna try and get guests on, like Failure, maybe Andy. I don't know who's gonna be available to pop in and start talking about this stuff, but it's a mess. And I would not want to be in Tonka's shoes. Now, there's also some confusion over about how some of the information came to light. It appears that it's possible that someone gathering information on Tonka may have also engaged in some questionable activities. And I think many of you can figure out who I'm talking about. And we may discuss that, we may not. But what I would suggest is not doing 90% of what was done. And I don't really endorse any of that activity. Of course, if there's anything unlawful, I have to specifically, tell people that you should not engage in that sort of activity. But I don't know the exact details. So I'm not going to say what definitely happened or didn't happen. But if you're looking for information on this, make sure what you're doing is above board, is legal. There's no misrepresentations or fraud happening on your end, because the worst thing to do is to try and point out someone else's crime and to commit one yourself. But like I said, I don't know what people are up to. I don't know what they've done to get this information. I just know that it's there. Hold on. We're going to open up today with some Navy Strength Gin called Kalevala. This is from Keck. Thank you, Keck. This is great. I also learned that Navy Strength means that when if it spills on the gunpowder or the ammunition will still fire. So it's got enough liquor in it for that. Good stuff. All right. Let's hit some chats, and then we're going to get into this. So this ink penification sent a justice chat long before the stream started. He says, "You come at the attorney, you best not miss Rekieta Little. Also tell Warski to leave Leafland. It's a nation that has led a party of traitors, and unless he doesn't win the next election, it'll get worse." There you go. I think he's talking about Trudeau. Trudeau winning the next election would be a disaster. Canada is also terrible. Except it's pretty. Some places it is pretty. And the Canadians are nice people, but the cuckery is strong with that one. Siren Jag says, I've come to enjoy the ability to silence mortal twat waffles that can often be earned on Facebook and Twitter just by making a statement using evidence, logic, and or common sense. Yeah, isn't that great? But unfortunately, it doesn't work enough. Landoname says, still got plans on next Weeb stream, buddy? Yes. There are 3 episodic streams that need to come back. Got to do a Weeb stream, got to do a Chad Dad chat, and we got to do another Big Brain panel all of those. I'm going to start reaching out to my friends and contacts to see when that will happen. If you're new to all of this, Weeb Stream is a discussion about anime, pretty much unrelated to law. So tune in for that. The Chad Dad Chat involves me and a couple other Chad dads, and we offer just discussion and thoughts on being men and raising families and being dads. So join that. And then the Big Brain Panel is probably the most evil show I do, where I grab other attorneys and we sit and we drink and we complain about something. Laws, courts, whatever it may be. So those are all fun, and I enjoy doing them very much, and they haven't happened in a while. So all three of those are making a comeback very soon. A Johnny Goldmain says, how much money is quartering going to get for getting punched? That's a very good question. It's a very good question. I do think that it's going to go. It's going to go on. I think the jurisdictional argument is a bad one. I think that the jurisdictional argument for Loader is a bad one. I don't foresee dismissal based on that. Surely it's possible. But yeah, as for how much damage is, I don't want to speculate at this point in time. I don't think he's going to get $400,000. He's, that's a high bar for it, but I think he could be awarded quite a bit. How much do I think he'll get? Probably not much at all, because I don't think Loader can pay. Bunsy the Frog says, in a bit late, did you mention how Brave is giving people $5 in credit to give to people in their BAT system, i.e. you, me, i.e. me? I have not mentioned that. But if you sign up for the Brave browser, which uses a Chrome base and has lots of privacy features and is frequently incorporating more and more Chrome plugins, you can also get their cryptocurrency, the basic Brave Attention Token, I think is what it's called, the BAT, and it can give it to creators, or you can have it allocate to websites that you visit. So it's pretty cool. Trump Nation says, serious question. When do calls, specifically prank/investigatory calls, approach illegality? R.E. Tonka. Well, that's a good question, isn't it? Prank calls, not generally illegal, so long as you abide by the recording limits, like of your state. Typically, it's a state where the recording takes place. If you live in a two-party state and you're recording that call, you better make sure that you have the consent of both parties. Prank calls could be drifting into harassment. It depends on what you do. It depends on if they ask you to stop. It depends on if you persist in trying to call them back. Investigatory calls, it all depends on your conduct during the call. And that's pretty tough to discuss unless you have more specific facts. Can you call a courthouse and ask if something has been filed in someone's name? Sure. They may tell you, they may not. Court documents tend to be public. Whether or not you can represent yourself as someone else, which is an allegation I've heard recently, less and less likely that that's okay. Okay. One final thing before we really delve into this is there is some merchandise out there. It's in the description below, right next to merch. I highly encourage you to look at the Smug Mug. The Smug Mug is one of my favorite things to say because it just makes me smile. There's a Smug Mug. There's a Rekieta Law mug. There's some shirts and stuff. There's another shirt. Coming out. I can't really preview it. It should be ready to go tomorrow. I'll be announcing it on the beginning of the Tonka stream because I think people will be interested in that. But definitely check out the merch store. Constantly going to be adding stuff to it. So And eventually, I'll probably be adding limited time runs of stuff, for people. So anyway, that said, I don't like to shill things too much, but I did hear that some of the first smug mugs were delivered and apparently are of very high quality. So that's great. That was from Sir Zaku that he got his, and it was great. So thank you for that, Sir Zaku, and thank you for everybody who has purchased the merch. If merch is your thing, don't buy it. Won't offend me at all. I only put it up there in case you guys want or like it. It doesn't cost me much of anything to create something. And if people want to buy it, then, that's great. That's great. Trump Nation, does streaming equal recording in the context of personal liability of the streamer who might assume the stream is being recorded by a third party? Very interesting question. Let's see. Context of personal liability of the streamer who might assume the stream is being recorded by a third party. I'm not sure if I follow your question. So are you talking about making a phone call on a stream? Does that, is that recording? Yes. Yes. Typically the recording is any interception of communication onto a medium of some sort. So yes, live streaming it would be recording, probably under the statute. So again, who might assume the stream is being recorded by a third party. The way two-party tends to work is that is the participants of the conversation being the two parties. It's not always two parties. It depends on the state, but a lot of times it's every party who's involved in the conversation. So you can't just say that I'm streaming plus I'm in the conversation, therefore we have two parties' consent if you don't have the consent of the other person. You got to check with your state, though. With your state. That's what really matters in this. Okay. I hope that helps answer your question. Landoname says, can't wait to talk to you soon, buddy. I got to head out early tonight to watch anime with my buddy. Have a good stream, Nick. Love you, Rick Nikita Daddy. I'm not Rick Nikita. That's someone else. But I do like Rick Nikita. Nick Rekieta is me. And I like you back, pal. I'm watching Baki on Netflix and enjoying how little sense it makes. Okay, Kyle Ferry says, Rekieta Dakimakura when? I don't know if Lady Raggets wants me to make one of those. But yeah. All right. Let's start talking about this. We got some big issues. Let me preview the 3 issues that we've got to start tonight. We've got the Supreme Court revives Trump's ban on the transgender military personnel for now. All right, so that happened today. We got Ruth Ginsburg reacts to Oscar nomination for RBG. Press X for doubt. Filmmakers are probably begging them to admit that chick is dead so that they can win an Oscar for it. And then here's the other thing. This is a bigger document that we're going to go through. This is the New York State Rifle and Pistol Association versus the City of New York and the New York City Police Department License Division. This is a petition for writ of certiorari. Certiorari. Whew, that's the worst Latin word there is. This is a petition for the Supreme Court to hear the case. The Supreme Court has accepted the petition to hear this case. So we're going to read what the petition was. This will be the first Supreme Court Second Amendment case to be heard in 9 years, because the Supreme Court definitely cares about the Second Amendment, and they really, really, really want to uphold the principles set forth by the Founding Fathers. And the Second Amendment is definitely not a second-hand or second-class amendment. No way. No. And when you read this case, when you go through this case with me, oh, Lady Rackets, are you in there? Make me my own chat log again. What? Make me my own chat log again? Lady Rackets? What are you talking about? Okay. I see you, girl. I see you, girl. When we read through this case and you find out what the issue is, I mean, put like a padding on your jaw or something so that when it hits the desk, it doesn't hurt. Well, it doesn't hurt. I don't want anybody to get hurt by this. Okay. Christopher Nelson, are you talking about the right-wing, the alt-right influence graph or whatever? The alternative influence network? I was not on that graph. I was not on that graph, but I think if they made it today, I might be. And that would make me extremely happy. Extremely happy. Like last night, you bum. At Rekieta Law. I know what you're... Make you your own chat log. Okay. You want me to... Lady Rackets, are you asking me to send subliminal dirty innuendos to you through the show? Maybe I'll do that. Hey, hi, Carrie Dalton. Welcome to the show. Carrie Dalton, you are an attorney, I believe. And if I remember right, you might have a practice area that might help somebody I know. Carrie, can you message me or email me? Because I might have something for you. I don't know. Someone is asking about the Glenlivet. Okay. The Glenlivet is up in my bedroom, so I don't have it with me. But it is a glorious Glenlivet Nadura. That is cask strength, and I cannot wait to have a little more of it. It's peated. It's a Glenlivet, so it's smooth and kind of a sweet scotch. But this is aged in peated casks, so it gets a little smoke and earth in it too. Okay. Here we go. Also, Lady Rackets, let me make you a moderator so I see your... there you go. Now I'll see your chats a little bit easier. All right. Hugh Janice says, how does it feel to make internet history with your Donga interview? Daddy, no! It's pretty fun. Yeah, Tess, you know I got you on networking stuff. All right, here we go. Ryan English, it's in my bedroom because that's where we unpacked from Tennessee. Why am I still talking about this? Let's talk about the Supreme Court. Okay. Here we go. Supreme Court revives Trump's ban on transgender military personnel for now. This is from NPR. Everybody's reporting on this, and of course, you know, they're all doing it that way. They're all doing it, you know, the same way. Tillip, don't take a big swig of Lagavulin 16, and also if you ever throw it up, you're fired. Ronald Crossman, have you ever tried Grangstone 18 year? If not, give it a try. It's one of my favorites. I'll take a look for it. Okay. Sorry. I'm getting distracted, chat. I got gin to drink and blood pressure to raise. The Supreme Court has reinstated President Trump's order placing restrictions on transgender persons enlisting and serving in the military by granting a stay of 2 lower court injunctions that had blocked the president's policy. I mean, it's almost like he's commander-in-chief of the military and able to set policy to, in his perspective, provide for the common defense. I don't know. It's almost like the president should have huge deferential authority when it comes to military policy, and almost like pretty much no one else has any authority on it at all. I don't know. It's kind of a big part of Article 2 of the Constitution that the president is commander-in-chief. commander-in-chief. The military structure is not the same as organized civilian society because it can't be. A military can't function as a democracy. Military is inherently authoritarian. Democratic militaries don't do war when you need them to. They just don't want to do it that day. So. I'm sorry. Here we go. The justices voted 5-4, reflecting the High Court's conservative majority. Put an asterisk by that 4. Put an asterisk. You know Ginsburg is not doing her job, right? Like, we know she's not actually listening to argument. She's working from home right now, which is a grave. Kyle Ferry says, at Lady Rackets, may Rekieta sell pillows as merchandise. Lady Rackets, he wants me to sell, what is it called? Dakimakura pillows. Is that okay? Can we do one of those? I'll get you one too. All right. Yeah, so we know Ginsburg. I mean, come on. Come on. The decision allows the Pentagon to prevent many transgender persons. Notice it says many. This is an important part. This is a very important part of the order and why it's not, why it's less likely to be unconstitutional. Okay? It doesn't prevent all trans people from joining the military. It only prevents many of them from doing so. It is not a blanket ban on transgender. It is a partial ban. Partial ban. Kind of like the Muslim ban, right? Who won that? Oh, Trump. Trump won that one. Okay. Or in some circumstances, remaining in the military while the lower court rulings that had blocked the policy are appealed. Again, these are issues that should not be in federal district court. I'm sorry, but we're talking about nationwide injunctions on presidential authority. Whew. I don't know. Bagel Goose masked me, although it didn't mask. Again, the racism of Streamlabs masking is frustrating. It says Ginsburg working from home, aka a tomb. Awig asks if a Supreme Court justice can vote from home. She is. So yes. I don't know. who's gonna rule that she can't? The court is the only people who can determine that, I guess. We'll see. All right. The justices did not allow the Trump administration to leapfrog the appeals court as it had requested. So they're going to sit in district court, then they're going to go through the appeals court, then it's going to go to the Supreme Court. The appeals court, depending on where it is probably going to reinstate the injunction. Although that would be silly, because if the Supreme Court is saying that an injunction's improper, then it's improper. The two cases, Trump versus Karnofsky and Trump versus Stockman, are currently working their way through the U.S. Court of Appeals for the Ninth Circuit. Weird. Both in the ninth. Who would have thought? How is it? I mean, it's just shocking that 2 out of 4 cases were raised in the Ninth District or Ninth Circuit. In both of those cases, Justice Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan would have maintained a stay on the ban. Tuesday's Supreme Court order reads. Oh, guys, the shocks are coming so hard. The transgender ban is the shocks are coming faster than Mike Pence's re-education camps. Transgender ban is being revived more than a year after a federal court in Washington, D.C. first blocked it in October 2017. U.S. District Judge Colleen Collar-Cotley. Oh man, I'm glad Colleen's a C. ruled that trans members of the military had, quote, a strong case that the president's ban would violate their Fifth Amendment rights. You don't have a due process right to be in the military. I guess. Well, maybe you do. I don't know. Coop says, how long do you think Ruth Bader Ginsburg can be not seen in public before a real cry for proof of life develops? Until 6 months before the 2020 election. A 3-judge panel of U.S. Court of Appeals for the District of Columbia Circuit lifted Caller Cotley's injunction earlier this month, concluding that the ban had been substantially revised by the time it was instituted by former Defense Secretary Jim Mattis in March 2018. But other federal courts had also ruled against the ban, and until Tuesday, those other injunctions remained in place. The 2 outstanding cases come from California and Washington State in the Ninth Circuit's jurisdiction. Pentagon rules. Under Trump's policy, transgender persons who have a history or diagnosis of gender dysphoria and who may require, quote, substantial medical treatment, including medications and surgery, are, with some exceptions, disqualified from military service. Why? Why would that be? Would it possibly be because these people are trying, allegedly, not all of them, but some of them might just be enlisting for the medical benefit that would immediately require drugs, surgery, and then leave them with a long absence from military duty if they could get their gender reassignment surgery paid for by the U.S. government and have a long leave time for their recovery. I don't know. Maybe that's why. Maybe not. Probably. That's probably why the government doesn't want that. They probably don't want to just pay for the surgeries of people and then have them sit during their enlistment. Darking D says, 40% of transgender people attempt suicide. Even activist research admits being in supportive environment only reduces that rate by less than a fifth. Transition therapy doesn't reduce suicide risk. People under suicide risk don't belong in the military. That's another interesting point. I don't know if that's a basis for the legal argument, but it is an interesting point that putting someone who's suicidal into a high-stress, non-affirming place like the military might push them to rash action. The exceptions fall into 4 categories. 1, the more than 900 active duty members of the military who a Pentagon report says were diagnosed with gender dysphoria after June 30, 2016. On that date, former Defense Secretary Ash Carter lifted a prior ban on transgender persons serving in the military. This group will be allowed to receive required medical treatment to transition and to serve in their preferred gender as long as they are not deemed non-deployable for more than 12 months. 2, those who have been, quote, stable for 36 consecutive months in their biological sex before entering the military. I don't even know what that means. 3, those who have been diagnosed with gender dysphoria after beginning their military service but, quote, do not require a change of gender. Again, the idea that you would enlist in the military to immediately receive surgery, putting you out of commission for military use, is silly. Why would the military want that? Like, you typically have to go through some medical exams. You have to pass certain physical standards. You have to do all sorts of things to get into the military because it confers a taxpayer-funded benefit, an expensive one. So to just pay people to come in and have surgery, get the surgery first, then enlist. That's allegedly okay. Bagel Goose says, this one probably won't work either, but it's my lamest mask, so it's okay. Sorry, Bagel. Sorry, buddy. Clip says, Posse Comitatus Act. Did I miss the video? No, I haven't done one yet. Things have been moving very quickly in other areas. I need to do one. I need to do one at some point. Okay. Those whom the Pentagon calls, quote, transgender persons without a history or diagnosis of gender dysphoria and who serve quote, in their biological sex. So there you go. Disqualified from serving in the military, according to February 2018 memo from Mattis, are transgender persons who require or have undergone gender transition. Mattis based his recommendations on a 2017 study he had ordered, in which a 2016 Defense Department survey estimates that about 1% of the active duty force, or 8,980 service members, identify as transgender. So there you go. Stark contrast between two administrations. Let me tell you the stark contrast. Trump hasn't murdered any American citizens yet. Saffron asks, do you call your viewers racketeers? Yes, we can do that. We can do that. Yeah, Trump hasn't sent drones to murder Americans without a trial. That's one stark contrast. What do they have to say? The Human Rights Campaign, oh good, which is involved in the Karnosky case in Washington state, condemned the Supreme Court's decision, saying it thrusts this administration's discriminatory agenda onto a military that clearly doesn't want it, and does so at the expense of transgender people's careers and service. The military doesn't want it, huh? That's interesting. That's a bold claim. Trump announced his ban abruptly in the summer of 2017, saying in a series of tweets, guys, did you ever suspect that we would have headlines where a president is announcing policy changes in a series of tweets? That the United States government will not accept or allow transgender individuals to serve in any capacity in the U.S. military. The decision seemed to take Defense Department officials by surprise, sparking confusion despite Trump's assertions that he had consulted with my generals and military experts. The tweets were followed by an official presidential memo in August of that year, which gave the Defense Secretary and, for the Coast Guard, the Homeland Security Secretary, the discretion to, quote, determine how to address transgender individuals currently serving in the United States military. Trump's ban was a sharp reversal of a Pentagon policy announced in June 2016, when Carter said, effective immediately, in June 2016. July, August, September, October, November. So Obama, with 5 months left, decides to foist on Trump a massive change in Pentagon policy. Effective immediately, transgender Americans may serve openly and they can no longer be discharged or otherwise separated from the military just for being transgender. So again, these people are acting, as they always do, as if this is some long-standing precedent, when actually it was brought about by Obama after his administration was effectively ended. Effectively ended. He had 7 months of time left in his 8 years as president, and then he immediately institutes it. Why would he do that? Why would he do that? Bort license plate says, is Trump's toupee considered an American citizen because he has clearly murdered that thing? Ooh, that's a good question. Probably not. Don't know if it's been naturalized. All right, here we go. The Obama-era policy was hailed as ending an era of legal and professional limbo for transgender persons in the U.S. Armed Services. Carter said the decision was made out of a desire to attract all talent possible to serve in the military. And Obama did have a strong record of attracting all talent possible to serve in the military, changing several policies, much to the chagrin or dismay of many people serving in the military. You know, I don't know. At the time, researchers at the Rand Corp think tank estimated there were as many as 7,000 active duty transgender service members, with up to 4,000 more in the reserves. Because of that policy and the lower court injunctions, the first openly transgender persons were able to join the U.S. military on January 1st, 2018. But now their status is once again in jeopardy. Effective immediately. Well, in a year and a half. Tuesday's order states that restrictions on transgender persons in the military will remain in effect until the Ninth Circuit rules on the policy. The stay would continue if the case is argued before the Supreme Court. So there we go. There we go. Supreme Court 5-4 says no. Probably 5-3. I honestly don't believe that Ginsburg is making decisions based on anything, because I'm pretty sure she's not lucid. But let's see what they have to say. You guys can decide for yourself. This also came out today. Did you guys know that there's an RBG movie, a Ruth Bader Ginsburg movie? Oh, and it just got an Oscar nomination. Did you guys know that? Have you heard about this? You hear about this? You hear about this? You hear about this? Here, look. Look, there she is, working out. Super diva. She's got her sweatshirt on. She's got a bunch of rings on. She's got those fives going, right? Clearly not her. I don't know what man is playing this part. Look at this weird look that they have for Ruth there. I never thought she looked particularly manly, only necromantic. But they got her looking like... It's like they put old makeup on Andy Dick and had him play as Ruth Bader Ginsburg. I don't know. Weird looking. Okay. Oh, wait. Is that actually her? Oh, no. The star of one of the year's biggest documentaries is a night owl, not an early riser. And probably had other things on her mind on Tuesday morning than her Oscar chances. So it fell to Betsy West and Julie Cohen, the directors of the documentary. Oh, that's not an actress, that's her. RBG to tell Justice Ruth Bader Ginsburg that the film was nominated. They called her at her Watergate apartment, where she is working from home. Supreme Court telecommutes now. It's good. Justice Ginsburg congratulated the filmmakers and said the Academy acknowledgement was eminently well-deserved. Is she borrowing Stephen Hawking's chair to speak? They reported barely suppressing their glee at getting to share the news with her. She sounded good, strong, West said as the justice recovers from her recent cancer surgery. She was very happy, and she has been following the blockbuster success of the film, so she couldn't have been too surprised. As a crowd pleaser, it may even be front runner in the documentary category. Might it be? No, you don't say. Are you saying that the Oscar Academy might make a Ruth Bader Ginsburg documentary when she's right about to die a front runner in the documentary category? What are the other documentaries that came out this year? What's the competition? Did Scalia get a documentary before he was killed? No. The directors and their spouses watched the nomination announcement together at West Manhattan apartment where her husband, Orrin Jacoby, an Oscar-nominated filmmaker in his own right, made them all scrambled eggs for breakfast. A page from the supportive partner playbook of Martin Ginsburg, the justice's late husband, and the cook in their family. Just like Marty Ginsburg, these are guys who had their own amazing careers, said Cohen, whose husband, Paul Barrett, is a law professor and journalist. In the last year, they have been just supporting our journey. As they geared up for production, the filmmakers briefly worried that notorious RBG mania would wane by the time their film hit screens. Oh, come on. Of course not. Of course it won't wane. She's dying. They couldn't have been more wrong. And the continued surge in interest in the justice's life, she's also the subject of the current feature On the Basis of Sex, has made the often grueling festival and award circuit more rewarding. Viewers from teenagers to grandmothers in blue states and red, but not grandfathers apparently, And sometimes progressive teens with their red state grandmas have found something to discuss. Like, hi, I'm a red state grandma progressive teen, and if I agreed with Ginsburg, you wouldn't have existed. Women of past generations, no matter where they are on political spectrum, face similar hurdles, Cohen noted. Many women can identify with the obstacles Justice Ginsburg encountered and admire how she managed to push them away at every turn. Like death. Darking D. Nick, what will you do if they figure out human immortality tomorrow and Ginsburg gets to sit on the bench for the rest of time? I will laugh. I'll laugh. I'll be live streaming her death for the rest of my life. George Glass says, before Scalia was killed? Have you done an analysis on that? Would love to see it. We all would. We all would love to see an analysis on Scalia's death. Unfortunately, they just happened to FedEx his body away and burn it before anybody could get around to autopsying a Supreme Court justice dying alone in a room with his head under a pillow. Shockingly, that little faux pas happened where he just happened to die. Only one of the most important and controversial figures in American politics, who could not be removed from office, who could not be voted out, who could only retire or die, just happened to die alone in a room on a hunting trip in Texas. And then he just we really want to do an interview because it's kind of important to find out why a Supreme Court justice might have died when they didn't think they were going to. And then they just mailed his body away. There you go. Did they kill Scalia? I don't know. No one ever will. I'm liking the wait what's in chat. I'm liking it. I'm liking it. Okay, where were we? It has not been tiring to talk about the film, West added. Women be talking, I guess. It has been energizing to be part of this conversation about Justice Ginsburg and let her life story represent both what she did fighting for equality and justice and what she continues to do now. It seems that her story just gets more relevant every day. Tick, tock, tick, tock. Tess, am I a birther? Nah, not really. I think the birther thing's funny, but no. Where are we? What we got next? Oh, let's finish this guy. Got this last bit of rabbit hole rye whiskey. Just a little bit left. Here we go. Tess, are you not curious a little bit about Scalia's death? Just a bit? All right. Here we go. By design, the film's top crew, from the cinematographer to the composer, were all women. The movie is also up for Best Song Oscar for the anthem I'll Fight by Diane Warren, now a 10-time nominee. Filmmakers did not want to speculate about whether Justice Ginsburg would attend the ceremony. Obviously, her priority is her work on the court. Wes said, "We didn't raise it with her. If she did make it, the selfie line for her would no doubt hold up the show. She might as well just host it. She's known for her pithy writing style," Cohen said, "so it could be a great match." Cohen was, she quickly added, only joking, "Still, a viewer can dream." There you go. That is Ruth Bader Ginsburg. Working out, living through the cancer, the pneumonia, and We'll see how long she lasts. Hmm. Tess? I don't know. I've seen law enforcement be incompetent before. No reason to think they'd be competent then. Okay, let's we're gonna move on to the Supreme Court case on guns because I like talking about guns. What are we doing here? Hold on, I'm trying to make this big enough for everybody to see. So this is a document directly from the Supreme Court filing, so it's a little bit different looking than the rest of my documents. Oh, excuse me. This is the this is the New York State Rifle and Pistol Association versus the City of New York and the New York City Police Department License Division. Here's the question. All right. Hey, what's up, Aiden? Nice to see you. New York City. So this is the question presented to the Supreme Court and why this is your argument as to why the court should take this case. Very important. New York City prohibits its residents from possessing a handgun without a license. And the only license the city makes available to most residents allows its holder to possess her handgun. Notice the her. That's subtle. Only in her home or en route to one of 7 shooting ranges within the city. That's useful. Here's your license to own a handgun. You can only keep it in your home or on your way to a shooting range, and presumably at the shooting range. The city thus bans its residents from transporting a handgun to any place outside city limits, even if the handgun is unloaded and locked in a container separate from its ammunition, and even if the owner seeks to transport it only to a second home for the core constitutionally protected purpose of self-defense, or to a more convenient out-of-city shooting range to hone its safe and effective use. That doesn't make any sense, does it? The city asserts that its transport ban promotes public safety by limiting the presence of handguns on the city streets. But the city put forth no empirical evidence that transporting an unloaded handgun locked in a container separate from its ammunition poses a meaningful risk to public safety. Hey, I got an idea. Shall not be infringed. Shall not be infringed. Listen to this. They're begging the Supreme Court. They're begging to have an unloaded gun in a container separate from ammunition, locked away in the trunk of the car to take out of the city. That's what they're begging for. Oh my God, where are we? Keep and bear. The right of the people to keep and bear arms shall not be infringed. Are we serious? This is the case, by the way, the Supreme Court is taking. And my God, if Gorsuch doesn't write the opinion where they say, burn New York to the ground, or let everybody have guns like they're supposed to, then we're lost. We're lost. This is insanity. This is insanity. I mean, are we... What? Moreover, even if there were such a risk, the city's restriction poses greater safety risks by encouraging residents who are leaving town to leave their handguns behind in vacant homes. This is a... And it serves only to increase the frequency of handgun transport within city limits by forcing many residents to use an in-city range rather than more convenient ranges elsewhere. What kind of argument is this? Like, we're reduced to this. This is insanity to me. I don't even know how to process this. Darking D says, repeal the Hughes amendment. Repeal the Hughes Amendment. P.S. To append my previous question, the most likely next life extension technology is looking like growing new parts of regenerative stem cell therapy. So what if she's not even old and sick as she sits on the bench forever? They just replace her with baby parts? That'd be great. Doug Confair says, shall not be infringed. Exactly. ISJ 322 says, I have to say, I didn't know non-lefty lawyers exist. There are some. Thank you for being a unicorn. FYI, the system you're talking about is basically what Canada used. Ugh. The question presented is whether the city's ban on transporting a licensed, locked, and unloaded handgun to a home or shooting range outside the city limits is consistent with the Second Amendment. Hey, let me give you a 5-4 ruling right now. No, of course not. The Commerce Clause, which shouldn't have anything to say about it, and the constitutional right to travel. Well, it's not infringing your right to travel. It's just infringing your right to have a gun while you travel. Oh. Parties. Corporate disclosure statement. Boring. Table of contents. Really boring. I'm going to read all that. Table of authorities. Here's the petition. Here's the petition. I can't believe we're here. I can't believe that this is the state of our country. Where are we? 10 years ago. This court held that the Second Amendment, quote, confers an individual right to keep and bear arms. DC versus Heller. 2 years later, the court held that this individual right is fundamental, applicable against state and local governments, and entitled to the same robust protections as other fundamental rights enshrined in the Constitution. That's McDonald versus Chicago. Two of the most important decisions of Obama's administration. The news has not yet reached New York City. It just hasn't, has it? Like, if only they could have found out that these rulings happened. Then they would. Instead, it is business as usual for draconian restrictions in New York, and this court's transformational rulings remain theoretical for the city's 8.5 million residents. They weren't transformational rulings. They were rulings consistent fairly with the Second Amendment, because they don't go far enough. They should have repealed the NFA, if we're being honest. US v. Miller is a tragedy. I know guns, beer, freedom. I know, buddy. I need to do a US v. Miller stream. I got it. It's a travesty of ruling that allows them to infringe all over us. That Cooper fellow says, this all bothers me. Correct me if I'm wrong, but the Constitution doesn't define my rights, but simply prevents government from infringing on my natural rights, which is what distinguishes the U.S. BOR. I don't know what BOR is. But yeah. The Constitution is a recognition of rights. It is not an exhaustive list of rights. It is a recognition of rights that we have. The understanding at the time that the Constitution was passed was that literally everyone would have a gun. Literally, well, every male anyway, because they would hunt. They would defend themselves. The rich men would duel with them if necessary. They'd carry them as showpieces. They carried them all over the place. Guns are a fundamental part of our country. Hey, they once needed to use them to overthrow the tyrants that were ruling them. Sic semper tyrannis. Oh, Bill of Rights. Bill of Rights, yes. Yeah, distinguishes the U.S. Bill of Rights. I thought you were just saying distinguishes the U.S. and then some additional, whatchamacallit. I can't even think of the word. Okay. Stream Me, Sour Grape Soda says, you'll never guess what direction the gun violence rates went after we implemented our current similar firearms restrictions. They went up because with them came heavier restrictions on self-defense. Of course they do. Okay. This is a case in point. Years before Heller recognized an individual and fundamental right to keep and bear arms, New York City put in place a prohibition on transporting handguns anywhere beyond city limits, even when they are unloaded and locked up in a container separate from their ammunition. Under that novel restriction, a New Yorker cannot transport his handgun to his second home for the core constitutional purpose of self-defense, to an upstate county to participate in a shooting competition, or even across the bridge to a neighboring city for target practice. While the city could have been excused for imposing such draconian restrictions in an era when the collective rights view of the Second Amendment remained viable, nothing changed when this court recognized an individual right in Heller, or when this court made clear that this right applies against state and local governments in McDonald. Instead, New York left this perverse, one-of-a-kind prohibition on its books, and the Second Circuit has now given that prohibition its blessing. The Second Circuit upheld that in a decision that perfectly embodies how lower courts have applied heightened scrutiny in name only to laws restricting Second Amendment rights, notwithstanding this court's express rejection of such an approach in Heller. It's a fundamental right. It should have strict scrutiny, period. Sharquisha Janalanisha. Talk about sovereign citizens. Oh, there's not much to say. Not much to say. Darking D. I think I'm going to start walking around with at least 2 pistols and a cavalry saber from now on, just to thumb my nose at the cucks in New York. Indeed, despite bearing the burden under heightened scrutiny, the city has presented precisely 0 empirical evidence that transporting an unloaded handgun locked up in a container separate from its ammunition, an activity that federal law affirmatively protects, poses any material safety risk. Moreover, the city's transport ban only undermines its professed public safety concerns, as the ban has the perverse effects of forcing residents to keep handguns in their vacant New York residences and to transport their handguns all around the city, the very activity the city claims is dangerous, in search of one of 7 in-city shooting ranges tucked into the boroughs. If this kind of showing satisfies heightened scrutiny, then this court did not mean what it said in Heller. And if that is truly the case, the word that Heller and McDonald amount to no more than rational basis or apply to nothing beyond flat ban should come from this court, not the Second Circuit. Oof. Making matters worse, the city's ill-conceived transport ban not only disregards any meaningful conception of the Second Amendment, but suffers 2 other constitutional infirmities. By restricting the use of lawfully purchased handguns to in-city shooting ranges, the ban violates the Commerce Clause, where the law clearly, quote, deprives the citizens of their right to have access to the markets of other states on equal terms. That's Granholm versus Heald. And the ban violates the fundamental right to travel by conditioning such travel on the forfeiture of a separate but equally important constitutional right. This case is thus an extreme outlier 3 times over, as the Second Circuit managed to uphold the city's novel ban only by distorting beyond recognition at least 3 separate strands of this court's jurisprudence. Simply put, the city's transport ban lacks even a rational basis, much less the heightened showing necessary to justify burdens on constitutional rights. This court should not let either that novel ban or the Second Circuit's indefensible version of the heightened security stand. Or heightened scrutiny. Strict scrutiny. Why are we not at strict scrutiny? By the way, Scalia, you deserve to be murdered by the government, I guess, for screwing up in Heller. It's strict scrutiny. What's wrong with you? This is Scalia's fault. This is Scalia's fault. He bears the burden. In DC versus Heller, he had the opportunity to make a better ruling. And he made a better ruling than what we had, but he left out some really important stuff. Matty P on the road. Any updates on open carry in the Ninth Circuit? I don't have it right now. The Second Circuit's opinion is reported at 883 Federal 3rd 45 and reproduced at App Fields 1 through 39. The order denying rehearing en banc is reprinted, blah, blah, blah. Jurisdiction. Yeah, petitioners filed a timely petition for rehearing en banc, which the court denied on April 5th. On June 21st, Justice Ginsburg extended the time for filing a petition for writ to and including August 3rd. On July 19th, Justice Ginsburg further extended the time for filing a petition for writ to and including September 2nd. This court has jurisdiction under 28 U.S.C. 1254-1. Scalia killed himself in shame. Constitutional and statutory provisions involved. Commerce Clause. U.S. Okay, this is all just a stuff. Not important. Statement of the case. Factual background. We've gotten the summary. Whoa. We need to do that. We've gotten the summary, but this is going to be the full case. This is interesting to me because this is how you make your argument to get your case in front of the Supreme Court. I think that's important for people to see what that looks like. And this one was successful, so we definitely want to cover that. Carrie Dalton says, don't overlook that he probably had to lower the standard in order to get Kennedy to join the majority. I mean, I don't forgive him. I don't forgive him. He's dead and Kennedy's retired, so I don't forgive anybody. It's a matter of state law. New York forbids its residents to possess handguns in their homes without a license. In your home! In your freaking home! New York penal law. To exercise his core Second Amendment right, residents must apply for a license to the licensing officer in the city or county where he or she resides. In New York City, the police commissioner administers a handgun licensing system. Again, we have to beg our government rulers to exercise our fundamental rights. Could you imagine if you had to have a license to speak outside or even in your own home? You got a license for that internet use? You got a license for that Twitter handle? I mean, it's England. Are we serious? Shall not be infringed. It is no mean feat for New York residents to get a license to, quote, have him possess a handgun in his dwelling. The application evaluation process includes, among other things, an assessment of the applicant's mental health, a cross-check of the applicant's statements on his or her license application, a criminal records check, and of course, a hefty fee. Commissioner may deny it because they don't like poors. They don't like poor people. Commissioner may deny an application for, quote, good cause. Unimportant footnote. But even getting such a license, known as a premises license, does not do a license holder any good if she wants to transport the handgun to a weekend home or take it to a convenient range outside city limits. Instead, under a restriction that predates this court's landmark decision in Heller, a premises license limits the holder's possession to the address listed on the license, with the sole exception being that the license holder may transport his or her handgun directly to and from an authorized small arms range shooting club, unloaded in a locked container, the ammunition to be carried separately. This is embarrassing. This isn't even a carry license. It's literally a I want to keep it at my house license. The one place where no one has any business in your affairs. I mean, you have... This is our compound. This is where we live. No one gets to come in without permission or a warrant, along with probable cause. They don't get anything, but they can say what's in there. And what's in there is your fundamental right. George Glass, I bet these 7 gun ranges love this law. I bet they do. Ooh, excuse me. Let's see. The commissioner's rules prohibit a New York City premises license holder from transporting her handgun to a separate residence. And the rules do not deem any range or shooting club outside of city limits authorized, meaning a license holder is limited to using shooting ranges inside city limits. There are only 7 target shooting ranges, exclusive of police or military ranges, in the entirety of New York City, a city with a population of 8.5 million people. Petitioners Romolo Colantone, Jose Anthony. Come on, guys! Give me something I can pronounce. Irizarry and Efrain Alvarez hold premises license in New York City. Colantone is a resident of Staten Island, has held a premises license for nearly 50 years. He owns a second home in Hancock. He owns a second home in Foot Penis, New York and Delaware County, and he wishes to transport his handgun to his second home and use it when he is in residence there to defend himself and his family. He has declined to take his handgun from the city to Hancock, however, for fear of a prosecution. Well, just buy another one. You got 2 homes, buy another one, right? That's the answer. Irizarry and Alvarez are residents of the Bronx and have held premises had held premises licenses for more than a decade. Colantone, Irizarry, and Alvarez all seek to transport their handguns to target ranges and shooting competitions outside New York City to hone their shooting skills. The same is true for members of Petitioner, the New York State Rifle and Pistol Association. Because of Section 523, however, petitioners and or their members have declined to participate in any shooting competitions or events outside the borders of the city for fear of revocation of their premises license and of criminal prosecution. Procedural history. Petitioners brought suit against the City of New York and the city's license division, alleging, as relevant here, the city's ban on transporting handguns outside city limits violates the Second Amendment, the Commerce Clause, and the fundamental right to travel. District Court entered summary judgment in the city's favor on all claims in an opinion that lifted long passages verbatim from the city's summary judgment papers. Purporting to apply intermediate scrutiny, but in fact applying something recognizable only as rational basis review, the court held that the transport ban is reasonably related to the city's interest in public safety and crime prevention. The court rejected petitioners' right to travel argument on the theory that the transport ban is a reasonable time, place, and manner restriction on the possession and use of a firearm. Finally. Look, it's a time, place, and manner restriction. Time, all of it. Place, all of it. And manner, all of it. We're restricting all of it. So it's reasonable. Sorry, guys. My hair's going to go all over the place. The court held that even though the transport ban does not allow petitioners to use out-of-city ranges to practice using their own firearms, it does not violate the Commerce Clause because, quote, the rule does not prohibit persons from purchasing firearms or attending shooting competitions outside the city without their firearms. You can go to the competition without your firearm. Throw the bullets. Hessian says registration is the first infringing step on the road to incremental confiscation. Absolutely. Oh, why don't we just have a big giant list of everybody who owns guns? Because it's not the government's business. Not the government's business. Petitioners appealed, and the Second Circuit affirmed. As to petitioner's Second Amendment claim, the court acknowledged that, quote, the ownership and possession of firearms in one's residence is, quote, where Second Amendment guarantees are at their zenith. Nope. Nope. And that, quote, the lawful use of those weapons in defense of hearth and home, its person, not hearth and home, is the core protection of the Second Amendment. Now, guys, obviously, if you know the Second Amendment, a well-regulated militia being necessary to the protection of a free state, the right of the people to keep and bear arms shall not be infringed. I mean, clearly, the core protection of the Second Amendment is laid out right in there, where the words, the lawful use of those weapons in defense of hearth and home. That's the core protection of the Second Amendment. It's right in the text. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Didn't you hear it? Didn't you hear it in there? The court nevertheless concluded that the inability to transport firearms from one residence to another, quote, does nothing to limit the lawful use of those weapons for that core purpose. With respect to the lawful use. So if they made it unlawful, then I guess then it wouldn't matter, right? With respect to Colantone, that's the whole purpose here, Second Circuit, is that the lawful use is an impermissible infringement on the freedom guaranteed by the Second Amendment. Cass, who needs to be mercy killed like Scalia? With respect to Colantone, the court held that the regulation, quote, does not substantially burden his ability to defend himself in his second residence because, quote, an adequate alternative remains for Colantone to acquire a firearm for self-defense. That alternative, the court explained, is that he could purchase a second handgun and obtain a license from a different county to keep that second handgun there. Of course he can. Of course he can. Well, you know what else he could do? He could just move to Texas and buy 50 handguns. That'd be a great way for him to exercise his Second Amendment right. No one's stopping him from doing that. Colonel Kraut, this is why we need strict scrutiny. I think this case may lead to it. Rather, I hope it leads to it. Yeah, that'd be great. The good news is this won't be heard until at least August. It won't be heard until the fall, most likely. And Ginsburg may be dead by then. As for petitioners' desire to practice with their own handguns at nearby target ranges and in shooting competitions outside the city, Second Circuit acknowledged that the right to bear arms implies the learning to handle and use them. No! It means literally having it with you. That's bearing arms. That's what it means. It means you can have them with you at all times, outside of very, very specific restrictions. Maybe, like in jail, can't bear arms in jail. Bort license plate says Colantone sounds like a product one would use for bleaching one's anus. buy me a. I need a vat of Colantone, please. But concluded that the transport ban does not, quote, impede petitioners, quote, ability to engage in sufficient practice to acquire and maintain the skills necessary to keep firearms safely and use them effectively. Do you think any of the cucks on the Second Circuit have a firearm? Have ever used one? safely and effectively. Well, who am I kidding? They have security to do that for them. Is this California law? No. Skull effer on Stream Me. This is not California law. This is New York. New York City. New York City. What do we got? God, I feel like I'm missing whiskey. Oh! Right. Got some Kieran whiskey here. Guess this is probably going to be my last sip of whiskey for the evening. Because, you know. Because. Sorry. I gotta take short breaks because I'll I don't know, I'll tip over a monitor or something. All right. That is so, the court concluded, because residents can take their firearms to one of the 7 target ranges that serve the entirety of New York City. So you can exercise your rights, your fundamental right. You can exercise it by going and paying a private business. That's how we exercise rights now in New York. And because the court assumed, albeit without identifying any record evidence on the issue, that other, quote, guns can be rented or borrowed at most such venues for practice purposes, in light of these conclusions, the Second Circuit held that petitioners' Second Amendment rights were not substantially burdened and therefore declined to apply strict scrutiny. You know what? Of course you can keep and bear arms by renting someone else's for a short period of time. Wow. Hey, what's up, real life autism streams? 088198823 says, foreigner here, is there any history of gun restrictions being repealed in the US after being passed? Yeah. Specifically by the Supreme Court in DC versus Heller in 2008. That was where the Washington, D.C. required you, for your handgun in your home, had to be disassembled or have a locking mechanism on the trigger. Not just unloaded, but actually either disassembled or with a locking mechanism on the trigger. That was repealed by the Supreme Court in 2008 in D.C. versus Heller. And then Chicago had a blanket ban on handguns within city limits. A complete ban on handguns. And that was overruled in McDonald versus City of Chicago. Okay. Okay, purporting to apply intermediate scrutiny. The court then held that the city had carried its burden to justify the encroachment on protected Second Amendment activity. The court identified the city's interest as protecting public safety and concluded that the city had presented sufficient, quote, evidence supporting its contention that the regulation protects that interest. So intermediate scrutiny is that you have to have an important government interest and a how's it worded? I never remember. Hold on. Let me I'll explain it. I just too much drinking. Okay, so for intermediate scrutiny, the challenged law must advance an important government interest by means that are substantially related to the interest in order to pass intermediate scrutiny. So a quick con law lesson here. Rational basis test means that there has to be a legitimate government interest. So it's the lowest thing. The government just has to have some sort of interest in what it's doing, and then the law has to be rationally related to that government interest. So extremely broad. Just doesn't like it has healthcare is an issue, for the government. So they're going to ban cheeses with more than 12% milk fat because of obesity. Like, ignoring everything else, that's theoretically possible because there's a legitimate government interest, which is the healthcare or the health of the populace, and then a rationally related law. Okay, so that's how they could do that. Intermediate scrutiny is an important government interest, so it's something above just legitimate. It has to be something a little bit more. What's important? What the court decides is important. And then it has to be substantially related to it, not just closely related to it, but kind of specifically related to the thing. And then strict scrutiny is it has to be a compelling government interest, which there are limits to a compelling government interest, protecting the life and property of the citizens, providing for national defense, stuff like that. And then the law must be narrowly tailored to advance that compelling interest in the least restrictive means possible. So that's the 3 levels of scrutiny that we have. Intermediate scrutiny is being applied here. So, the sole evidence on which the court relied in reaching that conclusion was a single affidavit from the former commander of the state licensing division hypothesizing, without any evidentiary support, that transporting an unloaded handgun locked in a container separate from its ammunition may pose a public safety risk in, quote, road rage or other, quote, stressful situations. Because what you're going to do is when you got road rage, you're going to go around to your trunk, you're going to open it up, you're going to unlock the locked compartment that your unloaded gun is in, you're going to pull it out, you're going to load it, you're going to chamber it, and then you're going to shoot someone. That's how road rage tends to work. And they're going to wait for you. They're going to wait for you to do that. The court did not explain how requiring city residents to spend more time transporting their handguns to inconvenient in-city ranges furthers the city's professed interest in reducing the in-city transport of unloaded locked-up handguns. The Second Circuit also rejected petitioners' claims that the transport ban violates the Commerce Clause and the fundamental right to travel. As to the Commerce Clause, the court concluded that the regulation does not facially discriminate against interstate commerce because petitioners can patronize firing ranges outside of the city and state, even though they cannot do so with their premises licensed firearm. And the court rejected the argument that the transport ban has an impermissible extraterritorial effect, insisting that it directly governs only activity within New York City, notwithstanding its total prohibition on transporting lawfully acquired firearms outside of the city. As for the right to travel, the court concluded that the Constitution protects the right to travel, not the right to travel armed. Okay. Heavy Fisted says, local news. Knoxville Civic Auditorium Coliseum adding metal detectors at all entrances. Did you all get too far out of hand this past weekend, Nick? We all were, well, my understanding, I was beeped down by a mobile metal detector from a very competent private security guard who waved it at my man parts, and that's how that went. So I guess they're going to add the metal detectors to streamline the process instead of having someone wand over every single person who walks through. Okay. ISJ 322 says, it'll be a race to load the locked cuck gun faster. It's the road rage, the new road rage race. Reasons for granting the petition. In the 10 years since this court held that the Second Amendment confers an individual right to keep and bear arms, the city of New York has doubled down on draconian laws enacted in the collective rights era with no analog in any other jurisdiction. Only New York City maintained a prohibition on loading more than 7 rounds of ammunition into a 10-round magazine, a nonsensical restriction that could not even survive rational basis review. And only New York City flatly prohibits its residents from removing their lawfully purchased and duly registered handguns from the city limits, even to transport them unloaded and locked up. leave New York, dear God, to second homes at which they are constitutionally entitled to possess them, or to out-of-city shooting ranges or competitions at which they are constitutionally entitled to hone their safe and effective use. Guys, I'm about to go get my gun out of the lake and shoot it in my backyard. I'm going to just shoot F's into trees for New York. That prohibition does not even make sense on its own terms. It has the perverse consequences of forcing New Yorkers to leave their handguns behind their vacant residences when they leave the city for an extended period of time, and far from achieving the city's professed interest in decreasing the amount of time that its residents spend transporting their locked and unloaded firearms to and from shooting ranges, an activity that the city made no serious effort to demonstrate poses any meaningful safety risk. The ban actually forces New Yorkers to spend more time traveling to the paucity of inconvenient in-city shooting ranges. Indeed. Indeed. Bagel Goose says, show us your toes. Show us your toes. I think it's Bagel Goose. It says anonymous, but I'm assuming it's Bagel Goose. Because he tends to use the masks. Indeed, the only plausible theory under which the city's novel transport ban could be understood to further its professed public safety interest in decreasing the transport of unloaded locked-up firearms is if the ban discourages people from transporting their handguns to shooting ranges at all. But it would be utterly irrational for the city to enact a restriction for the express purpose of making it harder for individuals to gain proficiency in the use of these handguns that the Constitution entitles them to possess. Not just to possess and bear. More to the point, a restriction that is expressly designed to make it harder to exercise core Second Amendment rights cannot plausibly withstand any level of constitutional scrutiny. Courts would not countenance for one moment a prohibition on leaving city limits to get an abortion. Of course not. Of course they wouldn't do that. They just don't want you to kill people in the city. They're happy if you kill babies in the city. And certainly not if there were only 7 locations in a city of 8.5 million people at which to obtain one. A prohibition on leaving city limits to exercise core Second Amendment rights should fare no better. Yeah, why don't we have licensed abortions? That makes sense. Philip says, I'm glad New York has these laws. Who wants criminals to be transporting guns in the city? Both the city's transport ban and the Second Circuit's decision sanctioning it are extreme outliers even among Second Amendment decisions. Indeed, if the Second Circuit's version of heightened scrutiny is what this court had in mind in Heller and McDonald, there was little point to recognizing a fundamental individual right and making it applicable against state and local governments. In fact, upholding laws like this under the guise of applying heightened scrutiny threatens to dilute heightened scrutiny. Heightened scrutiny is a fiction. It's a fiction. In other contexts, it undermines respect for the rule of law. This court recognized an individual right in Heller because the constitutional text plainly conferred such a right, and because ignoring that reality disrespects the founders' judgment and the reality that we are a nation of laws. There's little difference between denying... I mean, they don't care what the founders said. They don't care at all. There's little difference between denying a fundamental individual right by applying a collective rights gloss on the text and denying a fundamental individual right by applying a version of heightened scrutiny unrecognizable in any other constitutional context. The decision below plainly does the latter and calls for this court's review. Oh boy. So here are the 3 points. We're going to go through each thing now. Oh, excuse me. Okay. The city's ban on transporting handguns outside city limits is an extreme, unjustified, and irrational restriction on Second Amendment rights. Heller made clear that self-defense in the home is at the core of the Second Amendment right to keep and bear arms. No, it isn't. And Scalia, you sack of trash, you decomposing pile of vomit, It's not what the Second Amendment was for. The core of the right is to keep and bear arms, not for a purpose of defending yourself in the home, but for a purpose of keeping and bearing arms, defending the person, defending the property, defending other persons, fighting a tyrannical government, killing Native Americans, if we're being honest. Killing the English, killing the French, killing the Spaniards, killing whoever might be threatening the nation at the time. That's why the guns existed. Also because all men were part of the militia, as they still are part of the militia, because men are still required to sign up for selective service. We are the literal Minutemen. We can be drafted at a moment's notice. Very little way to protest that draft. Women can't. So maybe women shouldn't keep and bear arms. But men can. Men have to. Men were often required to own a gun, and if they did not own one due to proven poverty, the state would give them one. That's the core of the Second Amendment. That our nation would be ready to defend itself at a moment's notice. That the fabled Japanese general's quote, that behind every door is a loaded gun, and that's why America will not be conquered by a foreign invader. I'm paraphrasing. That would be a reality. Because yes, everyone should have guns. All of them. Yes. Even felons. Yes, everybody. Anonymous masked me and says, Bagel Goose. No, this is XXX69 Toe Sucker 420XXX, my alter ego. Siren Jag, good night, man. I'm going to be sick some more, which sucks, but I've lost 5 pounds in 10 days from not eating. Oh, sorry, buddy. Good luck with that, pal. Okay. Oh, okay. And the right to possess firearms for protection implies a corresponding right to acquire and maintain proficiency in their use. The core right wouldn't mean much without the training and practice that make it effective. That's Ezel versus City of Chicago. Indeed, as Heller itself noted, scholars have long recognized that to bear arms implies the learning to handle and use them in a way that makes those who keep them ready for their efficient use. That should have made this an easy case, no matter what mode of constitutional analysis one applies to Second Amendment rights. Starting, as most lower courts presently do, with the severity of the burden imposed on Second Amendment rights, the city's transport ban plainly imposes a severe burden on both the right to keep arms in the home and the right to hone their safe and effective use. As to the former, the ban flatly precludes residents from transporting their handguns to and from secondary residences outside of the city, even though there is no question that they are entitled to possess them in both locations. As to the latter, the ban restricts residents to honing the safe and effective use of their firearms in a mere 7 in-city shooting ranges in a city of 8.5 million. That's only 1.2 million people per, or 1.17 million people per shooting range. What are you complaining about? Yorgamund07 says, ironically, New York was a give poor men guns state. Of course it was. Of course it was. What's up, Hat Buckles? Long time no see, buddy. Glad to see you on Stream Me. Let's see. So this is quoting Whole Women's Health versus Hellerstedt, noting district court's conclusion that the proposition that 7 or 8 providers could meet the demands of the entire state stretches credulity. City's transport ban just as plainly cannot withstand strict, intermediate, or even rational basis scrutiny. At the outset, it bears repeating that the ban prohibits the transport of handguns. Even when they are unloaded and locked up in a container separate from their ammunition, the city submitted precisely 0 empirical evidence, no studies, no expert opinions, nothing to support the dubious proposition that the transport of unloaded, locked up firearms to shooting ranges, shooting competitions, or second homes, the only places petitioners seek to transport them, don't cuck on this, poses some meaningful public safety risk. The petitioners should want to walk around Times Square waving their guns around. That's what we need. Instead, the best the city could muster was a completely unsubstantiated affidavit hypothesizing that unloaded locked up firearms might pose some risk in road rage or other stressful situations. Suffice it to say, the Constitution requires stronger stuff than such cursory rationales. That's Heller versus District of Columbia and Ezel versus City of Chicago. The city cannot defend its regulatory scheme with shoddy data or reasoning, quoting Los Angeles versus Almeida books, and U.S. versus Playboy Entertainment Group, requiring more than anecdote and suspicion. Or supposition. Supposition. Gabriel Eving says, and the best part is effing Pittsburgh is trying to toss this right away. Everybody is. Everybody is. There's not a Democrat that I can find that that doesn't want to throw away rights. Like they might pretend to. They might pretend to. And like in Minnesota, very pro-gun state because of the hunting. Because of the hunting. But, oh my gosh. I don't believe them. I don't believe them because they're authoritarian. By nature, they want control. Fred Rush, MD. Hey, buddy, how's it going? Says, Nick, your Second Amendment rants make me so hard. Me too, buddy. Me too. The city's complete failure of proof is understandable, as any claim that transporting an unloaded firearm locked in a container separate from its ammunition poses a meaningful public safety risk is at considerable odds with the fact that the federal government treats those conditions as sufficient to alleviate all material public safety risks with the transport of firearms. That's C 18 U.S.C. Section 926A, entitling individuals to transport unloaded, locked-up firearms across state lines to places where their possession is lawful. Tomato Bread Orgasm says there's something viscerally satisfying about a SCOTUS smackdown. Well, let's hope we get one. Let's hope we get one. The city's defense of its novel transport ban thus should have failed at the outset, as the city could not even identify an important governmental objective to which the ban might be substantially related. And things only get worse for the city from there, even assuming the transport of unloaded, locked-up firearms pose some material safety risk. The city's ban does not even make sense on its own terms, let alone, in fact, alleviate the city's professed public safety concerns in a direct and material way. The city claims, and the Second Circuit agreed, that prohibiting its residents from transporting their unloaded and locked-up handguns outside of city limits will increase public safety because it will decrease the amount of firearms being transported across the city. But the city also claims, and the Second Circuit again agreed, that the ban does not burden Second Amendment rights because city residents could still transport their unloaded and locked-up firearms to the 7 shooting ranges spread across all 5 boroughs. By the city's and the Second Circuit's own telling, then, the ban actually increases the amount of time city residents will spend transporting their firearms throughout the city. Very activity that the city says is dangerous and that it claims to want to decrease because it forces city residents to use only in-city ranges, even when ranges outside the city limits are more convenient and involve less time spent on city streets. Transport ban thus either affirmatively undermines the city's objectives by forcing people to spend more time transporting firearms to get to inconvenient in-city ranges, in which case it cannot even pass rational basis review, or it achieves its intended end only by substantially deterring people from gaining proficiency in the use of their firearms, because if forced to use only in-city ranges, they will use no ranges at all, in which case it imposes severe and unjustifiable burdens on Second Amendment rights. Kush says, can't sleep, pouring a bourbon. Solid choice, buddy. Solid choice. Transport ban is every bit as nonsensical as applied to individuals who want to transport a handgun from one home in which they are constitutionally entitled to keep it for self-defense to another home across city lines in which they are constitutionally entitled to do the same. That restriction just guarantees that handguns that would otherwise be removed from the jurisdiction to a second home will instead be in a residence that lies vacant for weeks, if not months at a time. The city has never even tried to explain how that bizarre result could possibly further its professed public safety interests. Hey, what's up? Hat Buckle's on YouTube now. Hey, what's up, buddy? Yawn. Nick. Oh, yeah. Sorry. Oh, dude, rude. Oh. At bottom, then, the city's transport ban either substantially burdens Second Amendment rights or perversely proliferates both the number and the transportation of handguns within city limits. Either way, the transport ban comes nowhere close to satisfying any recognizable form of heightened scrutiny or complying with the Second Amendment. Second Circuit's contrary conclusion is inexplicable. According to the Second Circuit, prohibiting people from transporting an unloaded, locked-up handgun from one residence to another for the core purpose of self-defense in the home is not burdensome because people could just buy 2 handguns instead of 1. Court likewise reasoned that prohibiting the transport of handguns to out-of-city shooting ranges for target practice is not burdensome because New York City has 7 ranges to serve its 8.5 million residents, and because the theoretical ability to rent a different firearm for out-of-city target practice is a meaningful substitute for gaining proficiency in the use of their own handguns. Those conclusions reflect not only a profound disrespect for Second Amendment rights, but a profound disregard for the very public safety concerns that the court purported to be advancing. It does not begin to advance public safety to force individuals to buy multiple handguns and leave them in vacant homes. It does not begin to advance public safety to make it harder for individuals to hone the safe and effective use of the particular handguns that they will actually use should the need for self-defense arise. At bottom, the city's ban is not even rational, let alone meaningfully tailored in a way that takes seriously the notion that the Second Amendment protects a fundamental individual right. The Second Amendment could conclude otherwise underscores how far courts have strayed even from the teachings of this court's intermediate scrutiny cases. It is difficult to fathom courts finding such purported alternative avenues sufficient to render a ban on purchasing books or procuring an abortion outside city limits constitutional. This court should not countenance such a brazen attempt to treat the right recognized in Heller as a second-class right. But even in Heller, it's a second-class right! Even in Heller. It's a second-class right. No other fundamental right is so plainly protected and so brazenly limited. It's insane. Transport ban also violates the Commerce Clause and unconstitutionally burdens the right to travel. Its eagerness to uphold the city's restriction on traveling with a handgun to an out-of-state shooting range. Second Circuit turned a blind eye not only to this court's Second Amendment jurisprudence, but to this court's Commerce Clause jurisprudence as well. Court has made clear time and again that local governments may not use their regulatory power to favor local enterprise by prohibiting patronage of out-of-state competitors or their facilities. Yet that is precisely what the city's transport ban accomplishes. Any city resident who wishes to patronize a shooting range to train with her handgun can do so at one of the few ranges located in the city, but is forbidden from doing so at an out-of-state competitor. The decision below does not even mention CNA Carboni and its nearly 50 pages, despite that case's prominent role in petitioner's Commerce Clause arguments below, and the court's conclusory observation that the city's handgun transport ban is not discriminatory because, quote, it does not prohibit a premises license from patronizing an out-of-state licensee. A premises licensee from patronizing an out-of-state firing range or going to out-of-state shooting competitions misses the point. Legislation implicating Commerce Clause concerns will focus on commercial items and instrumentalities of commerce rather than directly regulating individuals. So it's not the fact that they could get another gun. It's the fact that their gun is a particular item that can be used in commerce to go to another shooting range out of state. Hat Buckles says hashtag lefty court. Yeah, no kidding. The fact that individuals may have alternative means to engage in commerce or travel would not mean that New York could limit access to certain highways to New Yorkers or command citizens to use articles of commerce only within city limits and nowhere else. The fact that state law discriminates in favor of or against state residents or in-state enterprises is enough to condemn such laws. I mean, imagine, and this isn't even a protected right, but imagine if New York tried to say you cannot transport a computer because a computer can be used to harm someone. You could not transport a computer to New Jersey, for example. That would be an impermissible restriction on the Commerce Clause. Super Action General on Stream Me. I will not talk Donga tonight. That is tomorrow night. I needed a little more time to get everything together as best as I'll be able to. So tomorrow night will be the first Donga stream. The handgun transport ban clearly prohibits city residents from patronizing out-of-state ranges and competitions in some circumstances, as it forbids law-abiding premises license holders from transporting their lawfully acquired, lawfully possessed handguns to engage in constitutionally protected commercial activity in another state, instead requiring that activity to take place within New York City. By any measure, then, the transport ban deprives citizens of their right to have access to the markets of other states on equal terms. Transport ban also impermissibly controls economic activity taking place entirely outside of New York City, in contravention of Healy versus Beer Institute Incorporated. Who doesn't want to go to the Beer Institute? Which provides that the Commerce Clause precludes the application of a state statute to commerce that takes place wholly outside of the state's borders, whether or not the commerce has effects within the state. Woo! Woo! Hat buckles. No, I've not done a specific stream on legislating from the bench. The Second Circuit resisted that conclusion by claiming that the ban, quote, directly governs only activity within New York City. But that is beside the point. Petitioners do not reside on the very boundary of New York City, so they cannot transport their handguns outside New York City without transporting them within city limits first. It is not a defense to a violation of a permit condition within the city to claim that the permit holder was on the shortest route to New Jersey range or beach house. Petitioners' complaint is that the city's in-city restrictions have the necessary effect of prohibiting them from transporting their handguns to places where they would put them to constitutionally protected uses outside the city. Imagine this, guys. With this law, Hamilton and Burr would have been unlawfully transporting their guns across the river into New Jersey to have their duel. As this court has long held, regulation of out-of-city conduct, not to mention a wholesale prohibition on certain out-of-state transactions, is a straightforward violation of the Commerce Clause. Oh no, Killstream invasion. Welcome, Killstream, to stream me. Thanks for popping over here. The transport ban is all the more problematic because it impedes not just out-of-state commerce, but out-of-state travel as well. A regulation implicates the right to travel when it actually deters such travel, or, quote, when it uses any classification which serves to penalize the exercise of that right. There can be no doubt that the transport ban deters travel, as petitioners have represented they would travel outside of the city and state but for this regulation. Indeed, the only thing standing between petitioners and participating in shooting competition in New Jersey, practicing at a licensed shooting range in Yonkers, or traveling to a second resident with their licensed firearm is the handgun transport ban. At bottom then, the decision below forces petitioners to choose which constitutional right they would rather exercise, their right to travel or their right to keep and bear arms. Petitioners attempt to exercise both these rights at the same time. They run the risk of having their licenses revoked, which would completely deprive them of their Second Amendment rights. The Constitution does not allow the government to put citizens to that choice. Again, it is difficult to fathom courts overlooking these obvious constitutional violations in any other context. If the city had banned its golfers from taking their clubs to out-of-state courses or its professional musicians from taking their instruments to out-of-state concert halls, it is hard to imagine those restrictions on interstate commerce and travel would be tolerated. That this case involves a restriction on constitutionally protected activity should have made the constitutional violations all the more obvious. Instead, the Second Circuit refused to apply directly on-point precedent for no apparent reason other than because this case involves handguns. Neither the Commerce Clause nor the Privileges and Immunities Clause contains any handgun exception. That the Second Circuit twisted three separate strands of jurisprudence beyond recognition, all in the name of avoiding enforcing the expressly enumerated right to keep and bear arms, only underscores what an outlier the decision below truly is. This case is an ideal vehicle for halting the spread of irrational and draconian restrictions on Second Amendment rights. We're almost done, guys. Just a couple more pages. While this court has declared that the right to bear arms is not a second-class right, many local governments and lower courts continue to treat it as such. Indeed, though the city's bizarre transport ban is one of a kind, it is exemplary of a broader push by local governments to restrict Second Amendment rights through means that would never fly in any other constitutional context. Unable to flatly ban the possession of handguns in the home, many local governments have responded by erecting obstacles to acquiring them. Well, they can't They can't get erections themselves, so they gotta erect something else. Others have effectively banned the ability to practice using handguns, and others still have imposed exorbitant licensing fees or even flat taxes on the right to acquire a firearm. Taxation is theft. The decision upholding this draconian law is exemplary of decisions diluting heightened scrutiny in the Second Amendment context beyond all recognition. Both these trends, governments disregarding Second Amendment rights and courts endorsing such efforts while purporting to apply heightened scrutiny, drain Heller McDonald of meaning and cry out for this court's review. No, Der Grobman, I've never talked to Leonard French directly, no. True to one of its nicknames, the city of Chicago has been second only to New York in its dogged attempts to nullify the Second Amendment within its borders. The city initially imposed an outright ban on the possession of handguns. See McDonald versus City of Chicago. When the court rejected the city's attempt to immunize that ban from the Second Amendment, Chicago responded, quote, by mandating 1 hour of range training as a prerequisite to lawful gun ownership, at the same time prohibiting all firing ranges in the city. That's Ezel, number 1. And when the Seventh Circuit struck down the range ban as unsupported by any empirical evidence, Chicago replaced it with an elaborate scheme of regulations governing shooting ranges, which had the effect of dramatically limiting the ability of to cite a shooting range within the city limits. Again, Chicago supported the restrictions with, quote, only speculative claims of harm to public health and safety. And again, the Seventh Circuit struck down the city's law. Unfortunately, other lower courts have not been nearly so willing to enforce Second Amendment rights. California, for example, imposes a Second Amendment tax by forcing every lawful firearm purchaser in the state to pay a $5 fee that is used to fund a police force tasked with hunting down those who unlawfully possess a firearm. Bort license plate says, hey, Beavis, Nick said erecting. It's been a long time since I've watched that show. Even though virtually no lawful purchasers ever unlawfully possess a firearm. When firearm purchasers challenged this regime, the Ninth Circuit held that the tax was actually a regulatory fee to offset the costs of firearm purchases on the offensive ground that criminal activity is an expense incident to an individual's acquisition of a firearm. Thus, while the government could never force newspapers to pay into libel funds or force court filers to fund those held in contempt, no one in California can lawfully acquire a firearm without covering costs attributable to wholly unrelated criminal activity by third parties. And that's why this right is a joke. It's a joke. Other jurisdictions have gone even further. Cook County, Illinois, for example, has levied a $25 tax on the purchase of firearms and a smaller tax on the purchase of ammunition. The county has abandoned any pretext that it seeks only to offset the costs of regulating firearms and ammunition purchases, and instead openly acknowledged that it imposed these taxes for the express purpose of deterring citizens from exercising their Second Amendment rights. The city of Seattle has also levied a $25 tax on all firearm sales to fund gun violence studies and anti-gun violence initiatives. Courts would never countenance, quote, a state law requiring purchasers of religious books to pay a nominal additional tax of 1 penny, much less a tax openly designed to deter exercises of First Amendment right. That's Planned Parenthood of Seattle, Pennsylvania. Wait, no, not Seattle, Pennsylvania. I don't know what SEPA versus Casey. That's Planned Parenthood versus Casey. That's important. But according to most lower courts, it remains an open question whether such taxes can be imposed on the exercise of Second Amendment rights. New York City is also not alone in ignoring long-standing Commerce Clause jurisprudence when it comes to Second Amendment rights. California recently passed a law that bans out-of-state vendors from selling ammunition to California residents via mail order or selling ammunition directly to California residents who intend to return to California with the ammunition. Instead, the out-of-state vendor must send the ammunition to an in-state vendor who processes the transaction and may charge a fee. Such blatant differential treatment of in-state and out-of-state economic interests that benefits the former and burdens the latter should clearly fail under clear Commerce Clause doctrine. But California enacted the law anyway, and if the Ninth Circuit adopts the Second Circuit's firearms exception to the Commerce Clause, the restriction will likely stand. Court decisions upholding such draconian regulations while purporting to apply heightened scrutiny are unfaithful to Heller and McDonald, pose dangers that extend far beyond the Second Amendment context. Much of the debate in Heller was over the proper mode of analysis for Second Amendment rights. While the court did not definitively resolve the level of scrutiny debate because the district's law flunked any form of scrutiny, the court did definitively reject both rational basis and an interest-balancing approach. As the court pointedly concluded, the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. But the decision below applies a form of intermediate scrutiny that would make the rejected interest-balancing approach look demanding. As this court already concluded, such a diluted form of scrutiny is simply inconsistent with the inclusion of the Second Amendment in the Bill of Rights. Almost done. Getting a little tired, and I ran out of tea. My voice is getting a little sore. But the threat to constitutional values posed by the decision below is not limited to the Second Amendment. A number of constitutional rights depend on heightened scrutiny for their protection. If courts get in the habit of applying heightened scrutiny and name only to the Second Amendment, only one of two outcomes is possible. Either courts will cabin that mistaken approach to the Second Amendment, or watering it down here will subvert its rigor in the other fields in which it is applied. The former is utterly inconsistent with this court's insistence in McDonald that the Second Amendment is not a second-class right. The latter is a threat to the entirety of the Bill of Rights. And either threatens respect for the rule of law in this court's decisions. This court should grant review to restore the rigor of the test that secures numerous individual rights and to underscore that it meant what it said in Heller and McDonald. For the foregoing reasons, this court should grant the petition for cert. And they got it today. They got it today. Big news. Huge news, because they've been rejecting Second Amendment cases for years. For years. All right, guys. I've had a long day. Had a long day yesterday. Not enough sleep. We're going to wrap this stream up. Thank you all for joining. Thank you all for joining. I'm going to go shove my face in some ice cream, read a book, take a sleep, take a nap, take a what? Why isn't this working? Oh, goodness. Rickard says, let's be honest, Nick. These fees are used to prevent the poor and minorities, the undesirables of societies, their right to self-defense. Absolutely. Absolutely. Remember, the left hates the poor. The left hates minorities. I'm not saying if you're liberal that you hate poor and minorities. I'm saying the left, like as a category, we know who we're talking about here. The regressive left hates the poor. They hate minorities. They want to control them. They want to be their sugar daddy, right? They want to go ahead and control their ability to live. If they keep them from self-defense, then they rely on the police and the government for self-defense. If they keep them out of jobs, then they rely on the government for welfare and food. That's the strategy. It's not even a hidden strategy. And yet, people who uphold freedom for all are the ones who hate. Catch you later, Hat Buckles, buddy. Don't be a stranger. Chicken Bone says, just subbed. This is great. Thanks. I appreciate it. Welcome to the show. We do this pretty much every night, talking about legal issues. If you guys are unfamiliar, almost every weeknight and some weekends, I stream currently at 11 p.m. Central. I am looking to move away from that 11 p.m. Central time slot. I will let you know when that happens, because I do not like competing with the kill stream. I do not like competing with Zidane's postmortem. Those guys are buddies of mine, and I don't like having to split audiences, especially when we got big stuff like the Tonka stream and stuff like that. So just know that I'm in the works, but guys, I'm still rolling back from, as you've seen with following some of these cases, law work takes a long time, and I have several cases still on the docket in my own practice that I need to clear out before I can reliably move to a more daytime friendly time slot. But it's in the works. It's in the works. Anonymous Bagel Goose says, oh, my mug came in today. It looks great. Good. I mentioned at the top of the stream, but for anyone left here, if you haven't checked out the shop below in the merch link in the description, there are mugs available. There are shirts available. There's another design going up tomorrow. The Smug Mug is my favorite product so far. Be sure to check it out, especially if you are a fan of Andy Worski or the Kill Stream or have been following this Tonka drama. And if you happen to catch my smug thumbs up during the Tonka stream, it is memorialized in mug form. And if you need a mug, get one. If you don't like merch, will not offend me by not buying one. But I think that's what we got, guys. So, peace. I'm going to go eat ice cream. Thank you, by the way, all you lovely subscribers. I've passed 17,000 subscribers today. The 15,000 subscriber stream is still coming. Subscribership has blown up since that Tonka stream. And I'm really appreciative of all of you, and I'm happy to have you here. But it does take a little bit of time for me to coordinate with my buddy because he is a dad. He is a dad and a hardworking man with a job and a schedule that is not a YouTube streamer. And he lives a couple hours away from me. So getting our families together takes a little bit of coordination, but it will happen soon. And we will have that 15,000 subscriber spectacular. And be sure to tune in for it because we will be talking about toxic, evil masculinity and how bad it is for our society. All right, guys. Thank you all. I'll talk to you soon. You guys have a good night.